Dear participants, a very warm welcome. As president of the European Law Institute, it is with great pleasure that I welcome you all to this first ELI webinar on third-party funding of litigation, so-called TPLF. Given the importance of the subject, we have decided to meet again in a couple of weeks for a second webinar on other aspects and with other people. This second webinar will take place on 11th of November 2024. The ELI project on principles governing the third-party funding of litigation has been approved by the European Law Institute Council on 17 September 2024 and by the ELI membership on 8 October 2024. It is now a full-fledged document that is available in the Council draft version on our webpage since the 9th of October 2024. It has been, I have to say, a fantastic work done by the two co-reporters, Professor Susanne Augenhofer and Judge Sarah Cockerill, to make this project rely on a very large basis, despite very opposite views in subgroups of stakeholders. I remember one attorney from New York at our annual conference in Vienna in 2023 being very much opposed to any funding of litigation schemes, whereas others considering that this is the only way to ensure access to justice to many claimants. Obviously, this project needed balance by the co-reporters and also a lot of inputs from various corners, including, of course, from the various bodies and members of the ELI. The executive committee, the scientific director, council members, and the membership at large all contributed also by hints, arguments, ideas to help the co-reporters to find the right balance. And this project therefore benefits from the work of a lot of collective thinking and interaction, as all the ELI projects. Even if the ELI project was still a draft, it was used and referred to by the UK House of Parliament to fuel its discussion on the issue of third-party funding of litigation. Needless to say that I'm thrilled to listen to the exceptional panelists we have today around the table. I will, as usual, present them as they speak. As always, you will be able to ask your questions thanks to the Q&A function, and we will answer those questions in the Q&A session after the first round of short presentations. But let's start with a brief presentation of the ELI principles on third-party funding of litigations by one of the two co-reporters, Professor Susanne Augenhofer. She's been a full professor of law at the University of Innsbruck in Austria since 2020. In fall 24, she serves as a visiting professor at Yale Law School, where she also graduated from the LLM program and has been a senior research fellow since 2021. In addition, she's a fellow at the Civil Justice Center at the NYU School of Law, and she currently serves as a member of the Council of the ELI, as well as a co-chair of the ELI Austrian Hub, and as a member also of the Advisory Group on Consumer Policy of the European Commission. Her research areas include transnational consumer law, as well as questions of aggregated enforcement. And with that, dear Susanne, I give you the floor for a brief presentation of these principles.
Thank you so much, dear President, dear Pascal, for the kind introduction. I have prepared some slides which I would like to share. Maybe you could give me a sign that you can see the slides. Perfect. So thank you again for the opportunity to be here today and to present our project. And I made a note to say something already now so that given the brevity of the time, I don't forget at the end. It has been such a privilege to work on this project together with my co-reporter, Sarah Cockerill, and I told her to interrupt me if I forget to mention something. And she has been really such a force during the last 2 years and 2 months. And every time when I thought, oh, too many loose ends with regard to our project, she knew the perfect answer. And thank you so much, Sarah, for the opportunity to work with you. And this brings me also to my first slide, the structure, how we worked during the last 2 years and 2 months. As Pascal already mentioned, we were supported by a lot of people to whom we are all very grateful. We started the project actually as 3 reporters. Initially, Professor Henrik Rothe was worked together with Sarah and myself as third reporter. He had then to withdraw from the project due to medical reasons in July 2020. And we were supported by initially 2 project assistants, Adrienne Dori and Joseph Rich, who really helped us tremendously to get the project off the start. And then also, especially Adrienne, who, among a lot of other skills, is a wizard with footnotes, helped us at the end tremendously. And we later, Christoph König, joined the project as third project assistant. We were also supported by the members of the advisory committee who are from different areas, as you can see on the slide, and different national backgrounds, and who were all very supporting, and we met with them a couple of times over the course of the project. And we are especially thankful also to the 3 assessors of the project, Xandra Kramer, Ross Anderson, and Lord Thomas. And of course, as Pascal already mentioned, we are also very grateful to the scientific director, Christiane Wenderhorst, with whom we also met a couple of times. I have already mentioned the time span of the project a couple of times. It was 2 years and 2 months. And I must say, I cannot remember that ever 2 years and 2 months passed by so fast, but there were so many different points to consider. And if you look at this timetable, you see that our project started not in a void, but maybe one of the triggers why we were commissioned to carry out our project was the so-called FOSS report, which called for more regulation of third-party funding. And the FOSS report, as I assume you all know, led to a resolution by the European Parliament. And as far as I know, the European Commission is still working on the so-called mapping study. I hope to hear more from Bia later on today on this project. So our project hopefully fitted nicely within the time span. And it was not only within the European Union that a lot of things have been happening over the course of the last 3 years or so. While we were working on the project, the UK Supreme Court in the Bakker decision had a very strong opinion on third-party funding. Maybe Sarah will say something more about this later on. And also in the US, some very important decisions have been made by courts over the course of the time we worked on the project. So we kind of hope that we finished this project at a good time to be considered for further considerations by different legislators. How did we start? We first identified 4 core objectives, which we tried to meet with our principles. And increasing access to justice is not considered, or is not the first bullet point on the slide for nothing, but we really had the strong feeling that third-party funding is needed indeed to increase access to justice for various groups of people, especially consumers. And we also tried to give, and hopefully succeeded, to consider the valid concerns about third-party litigation funding. We took into consideration that third-party funding is used basically these days globally, and different national concerns had to be considered. We tried to achieve we try to achieve leveling the playing field internationally between the parties, and also to consider legislative drafts which were already available. And the approach we took when we tried to draft the principles, considering those four objectives, can be described as a so-called light touch regulation. I think Sarah was the one who first coined this term. So what do we consider as light touch regulation? We considered that an overly prescriptive approach to the different contents of the funding agreement might lead, or almost inevitably will result in a loss of important access to justice for vulnerable claimants. And it might also lead to forum shopping amongst more sophisticated litigants. And we hence came to the conclusion that we should focus on information and also ensuring consistency and give the parties information about the agreement they are going to enter without imposing overly restrictive obligations on either party. And we hope that the outcome of the principles, which are now adopted, as the President mentioned at the beginning of today's webinar, help legislators in drafting new regulation on third-party litigation funding, but that they might also help judges when they have to consider already under the Representative Actions Directive whether or not third-party litigation agreements can be considered as fair, and also that the parties to a contract might use our principles as guidelines. And which structure has our project? We drafted 12 key principles, which basically deal with third-party litigation funding agreement from the start till the end. We start with the promotional materials and as principle 12 with dispute resolution and review by authorities or administrative agency. And we suggest the minimum content of agreements. We provide sample wording of such agreements. And we discuss in our so-called commentaries why we chose a certain approach and not another, and reflect on the arguments used. And then, in addition to the key principles and the wording examples we have and the commentaries, there is also the special considerations given to certain areas like consumer litigation, insolvency, and arbitration, because we had the feeling that those areas needed additional reflections and arguments, which might differ a little bit from the core principles. And we'll give you, given the time limitations, just two examples of our principles, and maybe we can discuss them further during the Q&As. So one question which is, and I dare to say it's disputed globally, is the question of disclosure. Do we funders and the funded parties have to disclose to the other party or the court either the fact that the dispute is funded or also the funding agreement? We came to the conclusion that it should the information that the dispute is funded should be given to the court and also the other parties, but we didn't we do not think, and hence our principles do not provide for this, that the details of the agreements should be provided to the other parties, which is the approach taken by the resolution by the European Parliament. And we can discuss this further, as mentioned before, but for brevity of this presentation. Just another example, which is Principle 8, funder fees. Here it is discussed whether or not there should be a cap on funder fees. The Representative Actions Directive does not provide for such a cap. Some member states, like Germany, introduced a cap of 10% when implementing the directive in the national law. We considered the different arguments for and against such caps and came to the conclusion that such a cap is not feasible. However, also in Principle 8, as you can see on the slide, and also as mentioned before by the President, the whole project is available on the website of the ELI. There's an information duty, what costs can arise and what fees. And then just a last point I would like to make, and as you can see, I really try to be very brief so that we have more time for the Q&As. As mentioned before, we have a second to last chapter of the project which deals with different areas as arbitration or insolvency law, but also with consumer law. We have a speaker today who will reflect on third-party funding in consumer law. But just some observations from our side, from the project. We think that it is important to point out that third-party funding is used in consumer law, but in different settings among the globe. For example, in Europe, it's mostly used in collective redress settings where not the consumer itself, but the NGO, the qualified entity, the consumer organization, is the party of to the funding agreement, which means that not the consumer must be protected, but we see that a consumer organization, which is a repeat player, concludes in the into the funding agreement. And in very few cases in Europe, individual consumers enter in the funding agreement. This is only the case when high amounts are at stake, for example, in product liability cases. It's different in the US because of the contingency fee because contingency fees are allowed in the US, there's less need of external funding, and hence we do not see so much funding in class action scenarios in the US. It's more in the individual cases that claims might be funded. So it's important to differentiate in which settings funding is used. And also with regard to funding of consumer litigation in Europe, it is important to point out that there's binding European law which has to be considered, namely the Standard Contract Terms Directive, and this comes to play if, in the very few cases, consumers, as mentioned before, individually conclude a contract with the funder. And Sarah and I would be happy to continue this conversation. As already mentioned, there will be a second webinar on November 11th, same time as today, different speakers, different topics we will cover. And the Austrian Hub of the European Law Institute is also hosting a conversation 2 days from today, also same time, also online, with Tony Seaborg, who was one of our advisors in his new book on third-party litigation funding. And I'm looking forward to the rest of today's evening and our Q&A.
Thank you very much, Susanne Augenhofer. Thank you very much for this, also giving us the background and the history, and also setting in some light on two very contentious principles, or maybe not the principles as such, but the issues addressed by these principles, as we will see. And we are happy to come back and discuss this in the Q&A, as you mentioned. Now we will go on, and you mentioned the European Commission. We have the pleasure to have with us Pia Lindholm. She works as a deputy head of unit for civil justice in the GJ Just and Consumers of the European Commission. She, as her name may indicate, she studied law in Helsinki and London, as well as economics in Brussels, and was trained as a judge in Finland. She joined the Commission in 1995 from the Finnish Ministry of Justice and started her career in the Commission's legal service. Therefore, she has worked in a number of different fields in the Commission before joining the Civil Justice Unit in 2017. Since 2020, she has followed the topic of third-party litigation funding, which belongs to the competence of the Civil Justice Unit. And as such, I'm sure she will be able to reveal to us a lot of interesting information. So you are welcome now to share your reflections on the ELI Principles project, and give you the floor. Thank you very much for being with us.
Thank you, Pascal. Good evening to all of you from Brussels. And indeed, our Civil Justice Unit is in the European Commission responsible for third-party litigation funding. Currently, our team is a two-person team. It's my colleague Jacek Garska, who is also participating in the discussion tonight, and myself. So we are two persons at the moment. And just a reminder that EU consumer issues are in the same Directorate General with us. So this is Directorate General Justice and Consumers, but we are the horizontal people. We are working closely with our consumer colleagues, but we are looking into the topic horizontally and not from the consumer perspective. I can be relatively short tonight because as it is usual at this stage of the European Commission's work, our reflection on a new topic when it's still ongoing. So we remain largely on a listening mode, and we feed in all the information we get from you to our reflection, but there is not so much we can say at this stage what will be the outcome. So just to shortly recall why we are following this topic, Susanne already showed the timeline with the key points, and there was a reference to Parliament's, European Parliament's 2022 resolution, where it was calling the Commission to propose legislation to regulate third-party litigation funding in the EU. And there is Commission's general political commitment when the European Parliament calls us to do something, we give a follow-up to that one. Just to note, for those who are less familiar with how the EU works, is that the Commission is the one having the a power of initiative in the EU. However, the European Parliament can indeed call us to act, but we have the power of initiative, so we have the final say whether we propose EU legislation in this field or not. And our follow-up to Parliament's call for action was basically, we agreed with Parliament's main recommendation that there is need to closely monitor and analyze the development of TPLF in the EU. However, we considered that we didn't yet have the full picture of the regulatory framework and practice of TPLF in the EU member states, to note that Parliament's action was very much based on evidence from third countries, so not so much from the EU countries. So we decided to launch a mapping study, which was already mentioned here, to gather information on the regulation and practice of TPLF in the member states. And that study is currently indeed ongoing. It's due to be finalized by the end of this year, so pretty soon. What is important to note is that the study doesn't have the same aim as the ELI principles. Our study is a mapping study, which is a fact-finding exercise, whereas the ELI principles, they are intended to constitute a blueprint for guidance, decision, and regulation of TPLF. So these are complementary and not overlapping exercises. We very much appreciate actually the work done by ELI to develop these principles. We consider they are very comprehensive, and from our perspective, the timing is excellent because our decision on the follow-up is approaching with the conclusion of the mapping study, and this is very useful input to our reflection. At the same time, it's one of the sources, so we remain open to all relevant information, and we use different sources. We use our own mapping study, but not only our own mapping study, but also all other relevant information. The benefits of the principle seems to be that they can be used in different contexts, so they fit into the context of EU regulation, if there will be EU regulation. They fit into the context of national regulation or self-regulation, for example, codes of conduct. Like the ELI states in the document, the principles are not themselves enforceable, but they can form a basis for regulation and self-regulation, so they can be used quite flexibly and for different purposes, which we think is very good. We have looked into the principle with my colleague Jacek Gaska, and as a general comment, we can say that we haven't really identified any gaps, which indeed shows that the principles are quite comprehensible. Just to recall very shortly that we have, from the EU side, we have a 2013 recommendation on collective redress, where we had some very general principles on funding of litigation, and also the representative action directive was referred to. Again, it's some very general principles. So you see that from our side, the work is not very detailed, very developed yet. It's at the level of general principles indeed. And we did looked into the implementation of the recommendation in 2018 and noted that member states haven't really implemented this principle. Of course, now we are looking again in the mapping study, so we will see what is the current state of play. So what we consider are the benefits of the ELI principles are really that they are taking the developments to next level in detail and reflection. what I personally found very good was the comments and sample wordings, which are very interesting and complementary to the main principle. And I think they're very useful for the reader, user of these principles. Then as a conclusion, just a few words. As I said, there is not much we can say at this stage. Nothing has been decided yet regarding whether there will be EU legislation or not. It's too early because we are still waiting for the mapping study. We really want to see the outcome of the mapping study. And those familiar with the EU and how it works know that we are currently approaching the new commission, the next mandate, as we call it, the next 5 years in the commission. So we will have new commission as a political body very soon, possibly the 1st of December, but the date is not known yet. And it will be for the new commission to decide whether this is one of the initiatives which will be taken forward at the EU level. And that will indeed depend also on the conclusions of the mapping study. There are currently some general documents like political guidelines for the next commission. These do not mention third-party litigation funding, but this is not meaning that anything has been decided, because if you look at the political guidelines, they are very general principles, very general guidelines. So they are not about the details of the projects which the next commission will take forward. And that is all from my side. Thank you for your attention.
Thank you very much, really, for this overview also of what is being done within the Commission, and its mapping exercise seems also very interesting. And I think that between the principles and the mapping exercise, the next Commission will certainly have everything it needs in order to decide to go forward or not, and also to decide which type of regulation, directives, or which type of legislation to adopt, if any. At least, as you mentioned, the project is sufficiently flexible enough so that it could also accommodate the various perspectives. So thank you very much for that. And we will continue now with a more specific perspective with Elisabeth Bragina. She's a senior legal officer in enforcement and redress at BOIC, the European Consumer Organization. Her role focuses on the private enforcement of consumer rights, with a particular emphasis on collective redress that has just been mentioned also by Pia Lindholm. Among other topics, Elisabeth addresses issues related to the funding of collective actions by consumer organizations, including, of course, third-party litigation funding. And therefore, she is more welcome now to express her views and reflections on the ELI principles for third-party litigation funding. Thank you very much for being with us, and you have the floor.
Thank you so much. Thank you for this kind introduction and for inviting me. I'm very happy to be here and very happy to share our reflections on the principles. But first of all, I would really like to congratulate ELA on these principles. It's a very important project and very timely, and it's really very well done. So congrats on this. And just to clarify, as was already mentioned, I will be talking more about this, not more, but exclusively about the situation when consumer organizations are the party to third-party funding agreements, so not the consumers directly, as these situations are not really that common in Europe, but that was already explained previously by Susanne. First, I want to mention that in the current situation in Europe, third-party litigation funding is really instrumental for consumer collective redress. We at BEUC very much advocate for public funding and for various public funding sources for collective redress. But unfortunately, reality remains the reality, and public funding is very often insufficient or completely unavailable for collective redress claims of consumer organizations. So in fact, as we also see in practice, if there wouldn't be third-party litigation funding, many successful collective redress claims just would never see the light of day because there would be no alternative funding source. It of course depends per country in the EU, but in many countries this is the situation. So for consumer organizations, it's extremely important that third-party litigation funding remains available. Against this background, we very much agree with the statement made in the principles that at this point in time, the additional litigation in third-party litigation funding should be only considered if there is a real problem or a market failure. And at this time, we find it a little bit premature. As was already mentioned, the Representative Action Directive at the EU level already established some important principles. And as some of you might know, 5 member states still haven't transposed the Representative Action Directive. So we find it too early now to assess what was the impact of these rules and whether there is a need for any additional regulation at the EU level. So at least at this moment, we don't support this. We will see how it will develop. Also, we think that RAD actually already established a very good framework of rules. For instance, it addresses such issues as conflict of interest and how to prevent the conflict of interest, how to prevent undue influence of funders. It also establishes the judicial oversight over the compliance with these rules. So we really think we need to give it a bit of time and see what RAD actually did in practice. But for the moment, we don't really see any significant issues in third-party litigation funding in Europe that remain unaddressed. We also support the view that's expressed in the principles and was also just repeated by Susanne, that when the rules are too strict in the regulation, that might, even though the aim was to help consumers and to protect their rights, it might actually disadvantage consumers in the sense that it will limit the funding options. And as I just explained, if there is no alternative source of funding, the collective redress actions just will not be brought by consumer organizations because they're very costly, they're very lengthy. So the appropriate funding is really key. So as a result of too stringent rules, actually, it might be the adverse result and the consumer access to justice will diminish instead of increasing. So we find the principles developed are very balanced. We find the approach taken by the principles very balanced. So indeed, the principles, as Susanne just explained, identify the key issues that the parties to the third-party litigation funding should look at, should take into account before entering into the agreement. And the principles provide guidelines on these key issues and assist all of the parties of the agreement. And we think this is a very balanced approach that the party can take the informed decision. And we also find it very helpful, which Susanna also mentioned, that the principle aim to also help judges, because in many EU member states, the collective redress is actually a very new concept. So before that, there was no collective redress or no class action or similar proceedings. So for many judges, it's also a very new topic, very new task, very new set of functions. So we think that could also be very beneficial for the judges. And of course, it would also be fantastic if judges take these principles into account and they implement it into their decisions. We think that would also be a very balanced way to increase transparency, increase fairness, but at the same time, still keep the flexibility of this relationship that are needed for consumer organizations and funders alike. Then if I still have some time, I can go a little bit more into specific principles that are important for consumer organizations, which consumer organizations really carefully look into and carefully monitor before entering the third-party litigation funding agreements. So first of all, for consumer organizations, it's extremely important that the funding sources of the funders are transparent. So it's important to understand where the capital is coming from. Then it's also very important for consumer organizations that the autonomy of the organization and its legal counsel is preserved, so that consumer organization and the legal counsel are the ultimate decision-making authority throughout the litigation. Then it's also very important for us to have very clear understanding on the all the expenses. And I think it's very well outlined in the principles. So it should be very clearly mentioned all stages of the litigation that are covered by the funding or not, which expenses are on the side of the funder, which are on the side of the consumer organization, and so on and so forth. I think the principles are very comprehensive in this regard. Then for us, of course, it's also very important for the consumer organizations that the funder remuneration is clearly defined, and also that it is reasonable and it is not diminishing the consumer compensation unduly. And here I can say that we also support the approach of principle that there is not clear established cap, because this is very difficult and it really should be, in our opinion, decided on case-by-case basis. But it is very well written also that there should be very transparent fee structure. So we fully support that. Then also the capital adequacy requirement of the funder. Of course, it's very important that funder maintain the sufficient capital. And we also appreciate the flexibility provided by the principles, that there are different options, different sample wording, because this can also be approached in a different manner, but it remains very important that there is, of course, a sufficient capital on the side of the funder. Then it's also very important for consumer organizations that funders comply with all the transparency requirements that are set either at the EU level or at the national level by the applicable laws. Then, of course, also it's very important that there is very robust rules and procedures on how to detect and disclose conflict of interests. And here also I found the principles to be very comprehensive, and they very well define the rules in this respect. Then it's also very important for consumer organizations that there are clear conditions for funding termination. We believe that there are indeed instances when it should be possible to terminate funding agreement, but they have to be very clearly defined, that there is no misunderstanding and no ambiguity in this regard. And the last thing that I will mention, and then I will definitely stop, we find it's important that the third-party litigation funding agreement agrees on dispute resolution mechanism. So it should be clear how any kind of disagreements between the funder and the consumer organization will be dealt with. That's all from my side. I hope I was more or less on time.
Well, what matters, thank you very much. What matters is more than the time is the substance. And I think you brought us a really an interesting insight also to the aspect that maybe with the principles and what exists already as a very general set of rules on EU level, there's a good supplemental play here, and that between commentaries, illustration, and all the various principles, it helps a lot to concretize some of the general principles already in the Representative Action Directive, the so-called RAD, as you mentioned. So thank you very much also for these various aspects. I'm sure we will come back on that in the Q&A. And now I wanted to say, let's take the other side, or at least the side of the perspective of the industry. And here we have the pleasure and the privilege to have with us Jillian Chamberlain, Stewart's risk and funding partner. And I mean, this enterprise has more than 200 million pounds and plus in litigation funding for the firm, working with 15 different funders. He leads Stewart's cost and funding disputes team, specializing in high value litigation funding, cost and insurance. Julian is recognized in the Legal 500 Hall of Fame and as a Chamber Star individual for his work for claimants with life-changing international injuries. He's active in numerous industry groups relating to third-party funding, including the CJC, wider consultation group, and the CLARB, and in relation to serious injury claims, as chair of the Forum of Complex Injury Solicitors and Ogden Working Group member. And with all this knowledge, I'm sure he will have also interesting perspective to hand over to us now. You have the floor. Thank you for being with us, Julian.
Thank you, Pascal, for inviting me to join this prestigious panel today. From my perspective, on behalf of the legal industry, the ELI principles provide a powerful blueprint for guidance, advice, and decisions on third-party funding. They helpfully assume and allow for flexibility between different jurisdictions and practice areas, rather than seeking to impose a one-size-fits-all approach. The principles rightly emphasize the importance of proper advice and information being available to a funded party to enable them to evaluate the key terms of funding agreements. Third-party funding agreements are long and complex documents. Anecdotal evidence suggests that the breadth and the quality of advice that many funded clients receive is often lacking. Now, that's not so surprising, as many litigation or arbitration lawyers may have never worked on a funded case. Others may have done so on a handful of cases spread out over many years of practice. It's a relatively small cohort of lawyers who regularly act in funded cases and have gained experience of a variety of funders and funding agreements. Consequently, I think there's a real skills gap across Europe on how to advise clients whose cases might be suitable for third-party funding, including considering the alternative or complementary funding arrangements like CFAs, DBAs, and ATE insurance. I think the authors of these principles have done the legal profession a massive favor by carefully researching these issues and how they're addressed around the globe. And if followed, these principles will better enable lawyers advising funded parties to undertake due diligence to inform funder selection, negotiate with the funders and draft fair agreements, and they can do that drawing from a useful palette of sample wording for key provisions. So I urge the law societies across Europe to promote these principles and use them to educate and equip the profession to advise their clients, or at least identify whether their clients ought to have independent advice. I thoroughly agree with the commentary in the principles that the lawyers who have the conduct of the proceedings owe their full professional and fiduciary duties to the litigants, and in the event of a conflict of interest between the litigants and the funders, the lawyers should continue to act solely for the litigants. But there is one aspect of the principles that I do take slight issue with, and that relates to the commentary around the definition of independent legal advice on the funding agreement. Principle 4.2 says that any party considering entering into a third-party funding agreement should seek independent legal advice, i.e. legal advice from a lawyer with no connection to the third-party funder. The related commentary then says that often the proposed lawyer to be instructed for the claim is seen as the independent legal advice. However, this is an unsafe model, particularly in a world where either via portfolio funding or simple repeat instructions, lawyers acting for funded parties may well have a financial conflict of interest. Now, in other respects, in these principles, great care has been taken to examine whether there is underlying evidence of a genuine problem before prescribing any significant limitations. I'm unaware of any evidence to show a widespread issue of financial conflicts of interest between the lawyers of funded parties and their clients. Any such conflict would in most jurisdictions already be addressed by the lawyers' regulatory codes. And unlike the dynamic for lawyers who maybe act as panel firms for corporates or insurers, funders very rarely bring their cases to lawyers, let alone provide repeat instructions. On the contrary, it's usually the other way around, the lawyer assisting their client to select an appropriate funder for their case. I do accept that in the relatively rare scenarios of the funder rather than the client selecting the lawyer, or lawyers who have a portfolio funding agreement that either involves them only offering a single funding option or having a broader financial interest in recommending that funder to the client, then that is, using the language of Principle 4.2, a connection to the funder that requires a transparent declaration and a recommendation that the client should obtain independent legal advice on the third-party funding agreement before signing it. But in the much more common scenario of the funder being chosen on a case-by-case basis, then I consider it's unrealistic, and who would pay for it, and often impractical to mandate for separate independent advice. The instructed lawyers ought to be trusted to provide independent advice on the funding agreement in accordance with their regulatory code. Where the lawyer has no broader connection or financial interest, aside from simply being paid for the work they undertake, which is inherent in all cases, whether funded or not, then there's, in my view, no genuine conflict of interests. The more common concern to my mind is whether the client has received well-informed advice. If the instructed lawyer lacks the experience to provide that, then they ought to recommend the client receives that advice separately. But I'm concerned that the principles or the commentary on them may go a little bit too far by suggesting that separate independent advice should be recommended in all funded cases. Principle 8 on funded fees actually flags a good example of the type of detailed advice that a separate firm advising on the funding agreement alone would not be able to provide without immersing themselves in the details and the dynamics of the underlying claim. Principle 8.4 states that it's not sufficient that these matters are included in the third-party funder's standard terms or conditions. They must be specifically explained to the funded party. And I thoroughly agree with that statement. And in my view, that ought to routinely involve the instructed lawyers ensuring that the impact of funder fees and all other deductions from claim proceeds are understood by the client at the outset. That will usually require modeling with conservative assumptions based on the alternatives of the case settling or proceeding to trial. That way, the client can make an informed decision with realistic expectations as to the cost of funding and their resultant likely net recovery. Now, I've not got time to comment on all of the principles, and many of the previous speakers have already done so, but I wanted to briefly mention just a few important points relating to control, termination, and funding disputes. The commentary on Principle 10 explains that the default position must be that the third-party funding agreement should leave the funded party in control of the conduct of litigation. And Principle 10.1 helpfully clarifies that any derogation from that starting point should be regarded as exceptional and needs to be clearly agreed, delineated, and recorded in the third-party funding agreement. And that's an important principle. Principle 11 is also essential reading for lawyers advising funded parties. It includes the important point that third-party funding agreements should not confer on funders broad discretionary rights to terminate the agreement. Any rights to terminate need to be specified and be very clear. And then finally, I agree, in the event of funding disputes, the principles will offer a useful yardstick by which fairness may be assessed. So there you have it. That wraps up my talk.
Thank you very much, Julian. That was really interesting, and of course, in particular, the issue of independent legal advice. I'm sure that Sarah or Suzanne will come back on that, and also, of course, the other very important point you mentioned. But before getting to the Q&A, we will have now a different perspective, the judicial perspective, as was presented earlier. This principle also intend to help not only lawyers, as you mentioned, Julian, but also judges to deal with these issues and try to have a kind of a yardstick how to deal with the various issues. And that's why we are very fortunate to have with us President Danguole Bubliene. She was appointed to the Lithuania Supreme Court in 2017. And since March 2023, she is the president of the Lithuanian Supreme Court. With extensive experience in the Ministry of Justice and Ministry of Education, she also practiced law for a decade, and she's a recognized expert in consumer protection. Bubliene has contributed to the EU law harmonization and numerous publications. She's a member of the Council of Judges, the Association of Judges, and Lithuania's representative at the Hague Private Law Conference. Today, of course, she wears her hat as president of the Lithuanian Supreme Court to bring us her reflections on the judicial perspective on these ELI principles. You have the floor. Thank you very much.
Thank you, Pascal. So good evening to all of you from Vilnius, from Lithuania. And I would like to say that it's my privilege to provide my reflection on principles from a judicial perspective. And let me start by expressing my gratitude for the great research, which provides valuable commentary on the various perspectives and risk areas of third-party litigation funding. I do not doubt that this will be an important reference in any judge's library, affording judges greater insight not only into the litigation funding system, but also in specific cases, helping to arrive at a decision. The principles will help to understand the third-party litigation funding scheme and the risks and pitfalls of such funding. While the principles note that third-party litigation funding is gaining popularity across Europe and this market undergoes rapid evolution worldwide, I must point out, although Lithuania permits litigation funding, its use here remains quite limited. Additionally, our legal framework does not require the disclosure of litigation funding in all disputes, so we lack comprehensive data on its widespreadness. There has only been one notable public mention of litigation funding in the country, and interestingly, it involved a city municipality using it to finance a dispute in arbitration. It was only with the transposition of the Representative Action Directive into Lithuanian law that a few key regulations concerning litigation funding were introduced, such as those addressing conflict of interest, limitations on funder control, and disclosure obligations. Yet, I would like to share how I see the principles from the judiciary perspective. In my view, litigation funding is multidimensional. Firstly, it falls within the realm of financial services market. Secondly, it involves contractual relationships. And thirdly, it serves as a tool to improve access to justice. The principles acknowledge that despite differing opinions, the courts have a recognized role in this area. Naturally, much of the discussion centers around the role of the courts in overseeing contractual relationships in third-party litigation funding agreements and ensuring access to justice. As we talk about contractual relationships, one of the most challenging areas is the issue of the funder's fee. This issue is acute regardless of the means for the fee control, either its maximum cap control percentage limit or just the control based on the general principles or in other way structured control. Any judicial intervention in the contracts, especially in terms of pricing, often raises significant debates and creates uncertainty. An unjustifiable low price can negatively impact the litigation funding market, especially since it takes time for a consistent judicial practice to form. In Lithuania, there are no specific regulations governing these contracts or the criteria for funder's fee control. However, if a dispute were to arise, these contracts would likely be evaluated in the same way as success fee agreements, with the funder's fee subject to the same criteria. That is, whether such an agreement violates general principles of contract law or public policy. Looking at recent Lithuanian case law on success fees in legal services contracts, we see that courts have sometimes found success fee agreements to be contrary to principles of fairness and justice, particularly in agreements involving consumers. However, there have also been cases where no violations of reasonableness or fairness was found, even when the success fee amounted to as much as 60% of the awarded sum or asset value. Courts have also examined whether these agreements conflict with public policy, but have generally not found any such violations. Of course, the next question in a contractual relationship is whether the court should control all other terms of the contract if there is an asymmetry between the interest of the funder and the funded party. There is a special instrument for consumer based on Unfair Terms Directive, but usually we do not have it in other relationships such as C2C or B2B. From the perspective of access to justice, when disputes arise over price or other terms of control or determination of a litigation funding agreement, they often lead to a separate process so-called satellite litigation between the funder and the funded party. However, aspects of these disputes can also affect the main litigation process that is being funded. A key question is whether these issues should be dealt within the main case, and to what extent they might influence its own outcome. For instance, if a funder decides to terminate the litigation funding agreement, what impact would that have on the litigation from the procedural standpoint? The Representative Action Directive also outlines a rule for the courts, giving them broad discretion in certain cases. However, the limits of this discretion and the procedural consequences of the court's involvement are not always clear. For example, the principle do not address whether there should be any penalties for a party that fails to disclose its funding arrangement. Should a judge impose sanctions if informed by the opposing party that the claimant is in fact funded? Should the court actively inquire about the existence of a litigation funding agreement if it suspects one? The principles in considering the different rules of civil procedure refrain from prescribing solutions to these questions. Nonetheless, more detailed guidelines on this issue could be helpful. Finally, I want to touch on the topic of the relationship of third-party litigation funding with litigation costs. Recently, the European Court of Human Rights reviewed a case, that is Lithuanian case, Narbutas versus Lithuania, and in this case, the court refused to award litigation costs to a party whose expenses were covered through altruistic crowdfunding. The reasoning was that the party had not incurred any actual costs, and awarding such compensation would amount to unjust enrichment. Although the principles focus primarily on non-altruistic funding, this legal issue, which is currently being considered also by the Lithuanian Supreme Court, highlights the need to consider how litigation funding affects the awarding of litigation costs. So, by concluding, I would like to thank you once again to Eli for this excellent work and vision, and wish just to continue to research on this very important topic. Thank you for listening to me.
Thank you very much. Thank you very much, President Boublianet. I think you put the finger on some interesting issues. And I don't know whether Sarah Cockrell will deal with that in her concluding remarks, but at least we will be able to come back to that, and the discussion will certainly continue also in relation with judges. Now, indeed, we will have some first concluding remarks by Sarah Cockrell as a kind of reaction of what was heard or presented, and then we will open the Q&A session, and of course everyone will be able to answer also some questions. So Sarah is a co-reporter. She has been a High Court judge since 2017 and was the judge in charge of the Commercial Court of England and Wales from 2020 to 2022. So during COVID, you can imagine how difficult that was. She gained a first-class degree in jurisprudence at St. Anne's College, Oxford in 1989 and was awarded the University Eldon Scholarship. She was in practice as a commercial barrister at Essex Court Chambers between 1991 and 2017, becoming a Queen's Counsel in 2011. She's the author of Compelled Evidence in Civil Proceedings by OUP in 2012 and is a regular contributor to academic legal conferences and seminar. And Sarah, I'm really happy to hand over to you for some thoughts or concluding remarks as you wish.
Thank you very much, Pascal. Thank you everybody for attending, and thank you very much to all those commentators who have appeared and given, I think, largely positive views about the principles. But before I go any further, I must respond to Suzanne and her thanks to me. I have to give the most wholehearted thanks to Suzanne. It has been such a fruitful experience working with her. It has been, for reasons which I will describe as I give my remarks, not entirely straightforward. Apart from the fact that we sadly lost from the project one of our co-reporters, the project actually was quite difficult in that where we thought we were going originally, we had to reconsider because it is such a complex, interesting and difficult area. And throughout, Suzanne has been fantastic, responsive, and it's been really great. And I'm also so glad I let her do this presentation because her slides are much, much better than mine. I must also echo the thanks to the rest of the team, including the assessors, the scientific director, and the whole of ELI for support and the kind of great comments that we got throughout. And when I say we were nervous coming to this webinar and having some external view, we felt we were very much getting wonderful, detailed feedback up until now, but from within the ELI family. So we were in a safe space until this evening. I think it's important to say, I think Suzanne may have slightly given the view that we came to this with the preconception that third-party funding is a good thing. I think overall, we came to it with no real preconceptions. The three initial reporters, all of us came to it from very different backgrounds and experiences. And we went into this open to hear from all those involved. And we had a very wide advisory committee who, we took a lot of information from. But overall, although throughout the project we have heard a number of voices speaking against third-party funding, urging caution or tight regulation, the vast majority of those with whom we've spoken throughout the project saw grounds for a real important use for third-party funding and value for third-party funding in the various jurisdictions. And some, as Dangola was saying, came from jurisdictions where there is very little funding, and there was a real sense that claims which exist out there and which should probably be brought could not be brought because of the absence of funding, particularly as regards collective redress, as Elizabeth was noting, but not exclusively so. And also, although, as Suzanne says, we eventually got to a position where we've developed principles which can be used in many ways, but I would probably say the thrust of them is that they form ultimately a good basis for light touch regulation. That was not at all where we started. And this is the difficulty that I alluded to. We initially contemplated a set of principles which would mandate or recommend certain approaches as preferable or reflecting best practice. And that's how we started with our feasibility study in our first drafts. And so I know there's a question in the chat about capital adequacy. We started with a recommendation that funders maintain capital adequacy to fund aggregate liabilities for all disputes funded for 24 months. But the more we looked at things, we realized that because of the range of circumstances in which these arrangements are found and the differing solutions that they can call for, it's one solution, one answer cannot be right in all circumstances. And that feeds into another question in the chat about what is the right return for a funder? Well, the right return for a funder, ultimately, we were persuaded, depends on the case, the risks, and a variety of other factors. So what you'll find in the notes for the principles is on funding, on funders' returns, a checklist of the kinds of points which will feed into a funder's consideration of what the right fee is. Now, there are some benchmarks out there in various jurisdictions, like 30% or so forth. But the point that we came to was that it would be wrong to go for 30% because it'll be too high in some cases and it might be too low in others. You have to take into account all those considerations. So that is why we had a little difficulty in that we started writing one thing and we ended up writing another. But so the entire process has been a learning process. And I think because of that, it's fair to say, as I said before, we were very nervous this evening to hear the principles discussed outside the ELI family. We're obviously particularly glad to hear from PIA and the EU, albeit on a very early and preliminary basis, and not dealing with outcomes, that what we have produced is something which will be useful to her team's reflections. I could not agree more with her that it's an area, third-party funding, is one where one needs to closely monitor and analyze development. it is an area which requires real care. Although we are entirely convinced it has value and use in many cases, it is absolutely right that there are dangers. And so I'm very glad that Pia thinks that it will be useful, that it's got no gaps. That's a great relief. I'm particularly delighted to hear that she sees the value which we had always hoped that users would see in the sample wordings. They were controversial as we went through, but came in because when we were trying to come to right answers, they were possibilities. And we also became aware of how difficult it is to visualize how these issues play out in real life. When it comes to collective redress, I'll let Suzanne largely deal with this, as it's very much within her area of expertise. But I was so very glad to hear Elizabeth endorsing our view that while regulation is something which needs to be carefully considered, it needs to be carefully and hesitantly considered, in that a market needs to be allowed to develop. And the word which she used of balance strikes such a chord with us. Our view was very much that balance is key. It is the balance between the advantages and the disadvantages, and it's the balance within the agreement. And that feeds into Julian's comments. Of course, Julian understands how these agreements actually work. I loved his mention of the skills gap. That is something which we did very much have in mind. And although I think the way the project has developed, we are in a position where the principles can be used in a variety of ways. I think at the forefront of our mind was the potential user of third-party funding who doesn't have the knowledge and the information that the funder will have. If funding can be useful, and it can be useful, it can be safely used, so long as both parties understand the risks, the advantages, the balances, the interplay of issues. It wouldn't be a proper debate and webinar if somebody didn't come up with something to quarrel with, and I was relieved it was only the question of independent legal advice. Julian took some issue with this as regards financial conflicts of interest. I think maybe in the interests of controversy, he has overstated what we have put in the commentaries. All we have said is, I think the principle says that there must be no link to the funder, and we have highlighted the risk in the commentary. Of course, it is not an issue if there is no financial link. The point is to emphasize the importance of being sure of no link and of the quality of advice. And he moved then into what I think is the important point, which does link to this, the importance of well-informed advice. The fact that lawyers who are instructed, even if they have no link to the funder, may not be well placed to give that detailed, sophisticated advice, appreciating the kinds of points that Julian has highlighted, even apart from conflicts. These are really well-made point. And it may well be that this is an area where specialist advice may be a growth area. And then coming back to Dangora's points in the last contribution, I was so interested to hear what she said about, both the lack of third-party funding within her jurisdiction, but also the lack of data. I obviously come from a jurisdiction where we have lots of third-party funding, and we lack data too. That is something which we share. And in the end, our position on disclosure in the principles was actually in part driven by this. As Pia will be, and her team will be thinking about at the moment, this is third-party funding is a very important area. It's having big impacts, not just in what cases are brought and so forth, but my one concern, which I have highlighted on a couple of occasions, is the impact on litigation costs. What is going on in the third-party funding market is very important, and yet getting that data, robust data, is very difficult. And I wish Pia and her team every bit of good luck on that. I'm so gratified to hear that it's thought that the principles will be helpful to judges as they deal with third-party funding issues, before a market develops to a point where funding, where regulation is appropriate. We were very hopeful that the principles would help the potential customer of third-party funding, potential regulators, but also judges, because as I know only too well, these issues bubble to the surface quite often, and some principles, some guidance is, well, we hope will be very useful. I don't know that there's very much else that I need to say at this point, and we're probably about the point where you want to go to questions, Pascal.
Yes, so that thank you very much, first of all, for taking up the various points and doing that so beautifully. And indeed, we got a number of written questions, and I think that could be interesting also to get back to those. And maybe the first question I wanted to, because you answered implicitly at least some of them, but one seemed interesting to me, and that's a question for Julian, in fact, linked to this independent legal advice. And well, there is a reference to this Petronas Azerbaijan case, and that's not the aim of the question, but the question is really, how can the claimant get independent legal advice if the funder will be paying on behalf of the claimant for the independent legal advice? Is there here not a problem of circularity, and how do you see that in practice?
Yes, thank you, Pascal. I mean, of course, if a client does have money to pay for their advice on funding agreements, and some of our clients do, then they can and do that during the process of us advising them on funding agreements, potentially with a beauty parade of different funders. But I appreciate there are also wholly impecunious clients who can't afford to do that, particularly when we get into the consumer space. And that is a more difficult issue, because third-party funding is not legal aid. That is very clear. The authors of the principles make it clear as well. Nor are the law firms who advise clients on funding or represent them in their litigation or arbitration are not providing, a state-backed service of legal aid either. These are all commercial firms. They may do some pro bono work. They may be willing to take some risk in appropriate cases in relation to their fees, if their national laws allow them to even do that in the first place. But there is a conundrum there. I mean, I think we do sometimes see with meritorious cases, some funders willing to provide seed funding, which would also include providing for the client to have the independent legal advice during that period of finalizing the funding agreement. And I come back to the point of those lawyers taking their regulatory duties very seriously. I mean, the fact we may end up being paid by a funder does not in any sense, to my mind, dilute the fact we are acting for the client on the client's instructions. There are some really, really important points about that set out clearly in the principles, and I think the principles neatly reinforce that issue.
Thank you very much for that. I think it's very useful. I was just wondering, because Dagonle Boubliene mentioned the issue of the consequences in case of non-disclosure of the third-party funding, and whether this should have any consequences on the litigation itself, or whether the sanction should be something distinct from the litigation itself. And maybe, Sarah, as you are a judge and a commercial judge, maybe I can bring this question directly to you, because maybe I know you have discussed that, and I'm sure you have some reflections here to share.
No, it's a very, very good question, and one I hoped you weren't going to ask, Pascal. The consequences of non-disclosure within the litigation, I mean, I think that must be jurisdiction specific. Obviously, so far as the principles go, the principles themselves stand free. They have no specific consequences unless and until they are brought into effect in some way. But I can certainly imagine that if you adopt the principles as, say, best practice or the basis for usual practice, that the absence of disclosure of funding in the litigation might result in cost consequences, potential stays for a period of time, some other form of procedural sanction. I don't think, I mean, it's not the kind of issue which would go to striking out the litigation or anything of that description. But it's an interesting idea, because we've thought of various other things as, you know, within the litigation funding relationship, and that is an external point. And it was actually, I think, the single most controversial point within the principles, certainly as between Suzanne and myself.
Thank you very much. Indeed, one would probably have to think about what is the purpose of disclosure, and therefore the sanction should be aligned with the purpose of disclosure. And so, as you mentioned, maybe the issue of cost and maybe also the amount of damages awarded, because there might be some, at least indirect influences. Julian, you wanted to react maybe.
Yeah, I was just going to make a sort of standback point that, of course, there in very few jurisdictions is there any obligation on a party to disclose that they're insured in a dispute and that their insurance might be funding their legal representation. So I think we need to, when we view this issue about funder disclosure, take a step back and think, is that a requirement that goes broader? And if it doesn't, why is it we're requiring funder disclosure but not insurance disclosure?
Thank you very much. Susanne, you wanted to react as well.
Yeah, I also want to echo what Julian said, that we should not forget, just because we are talking about third-party funding, the general contract and procedural rules apply. But what I wanted to add is that, and I'm looking to Pia and Elizabeth, and I hope you correct me if you think I'm totally wrong, but the failure to disclose funding from outside might, under the Representative Action Directive, impact the standing of an NGO as qualified entity, as under the directive qualified entities have to be independent from any influence from a funder unless it's disclosed. So it might already affect the lack of disclosure, not only the litigation at stake, but the qualification of a consumer organization as a qualified entity.
Thank you very much, which, as we know, it's a severe consequence for all these parties that are brought through this representative action. Yeah. Maybe we still have a little bit of time. So I wanted to take now the other side, because there's a question still about disclosure, but now disclosure, if there's a false statement to the funded party by the third-party litigation funder. Of course, we've heard by Julian that everyone is doing always the best and behaving perfectly properly. But if something happens, what would be the consequences on this relationship? How do you see this impact, and do the principles address the issue here? Sarah or Suzanne, do you want to answer this question?
Sorry, if there's an absence of disclosure, by whom to whom?
No, not an absence of disclosure, but a false statement by the funder to the funded party, to the association, for instance, either about the committed capital that is being provided, or about some important aspect that, according to the principles, need to be disclosed. What would be the consequences, and how the principles deal with that?
Well, the principles don't specifically deal with that. What they do is set out what should be done, and then the question of sanction would either be if you haven't provided for sanction within any enabling or enforcing regulation. It would be a matter for the ordinary law which applies to the funded party relationship, so actions in misrepresentation and so forth. But it is the kind of thing that any country or organization which was putting in place specific regulations might want to make a specific sanction for that once you are making the principles enforceable. I mean, all of these things, really, the principles start as best practice advice, a structure from where you should be looking. And then if you look to put them into a particular format, either regulation or contractual or so forth, you then have to think about the sanction in case of breach of any of these aspects of the principles.
Exactly. Thank you very much for this answer, because I think it's very central to realize that with this triangular relationship, and then you have the judge, of course, as well. You have these contractual relationships. So, of course, the ordinary contractual remedies will apply in this relationship between funder and third-party funder and third-party and funded party, so that that will not necessarily come from the judge or from, I don't know, regulatory, where maybe supervising authorities over the third-party funder, but not necessarily from the judge and so on. So the tradition, as mentioned by Susanne, the procedural devices still work for the relationship towards the judge, and the contractual, of course, remedies would work as well.
And maybe even criminal
Yes,
law.
please.
And
Yeah.
but of course, I'm not a criminal law expert, but if I think this is the case of fraud, and then we have misleading advertising. It would
Indeed,
also,
indeed.
if it would false information would be publicly available, it's also a case of false fair trading law under commercial practices.
Indeed, indeed, and that shows the complexity. And maybe I will end by that, because we're coming to the end of the time allotted to us. But this shows the complexity with which the two co-reporters and had to deal with, while using their best efforts to find a balanced approach to these principles of third-party litigation funding, because you have contractual issues, you have procedural issues, and you have a lot of different perspectives depending whether you look from the judge's perspective or from the party's perspective, litigant. And one could say, why would the judge need to know about the third-party funding? Because if it's my father who funds my lawsuit, maybe no one cares, but suddenly, because it's an entity, a third-party entity, it might become more important. So it's all a matter of balancing. And we've heard this evening that well, you did very well in finding the right balance, and in identifying a lot of the various issues, commentaries, of course, being very helpful, and illustration as well. That to say that, again, I think that the European Law Institute can be proud of these principles. And we are looking forward, of course, to the further discussion of these principles, because now, as we have seen, we touch a couple of issues, but for each principles, we had lengthy discussions within the organization with the co-reporters, but also we look forward to have extended discussions with BOIC, with other entities, in order to see how these could be implemented, or to train judges with these principles. Let me, in a way, to conclude this evening, let me thank all the panelists for the time, the efforts, and the very useful insight they brought on this webinar, to reflect on these principles, but more generally to reflect on third-party litigation funding. And as mentioned at the start, we will have a second different webinar on third-party litigation funding on the 11th of November. So you have the link also in the chat. So stay tuned. You may already register to have different views, different speakers, and maybe also different ideas to go on your path on reflecting on third-party litigation funding. Thank you very much for all panelists, to all panelists. Thank you very much to all participants, and I wish you all a very nice evening. Thank you. Bye-bye.